I have a question that I'm going to ask all council, and I'd like your view on it. First, is the unallotment statute a delegation of legislative appropriation authority, or is it merely a codification of procedures for the exercise of the executive's spending authority? Is it a delegation or is it a codification?
Well, I believe it would be a delegation of authority.
Thank you. And if it is a delegation of authority, what standards govern its exercise other than the timing standards?
Other than the timing standards, the standard with respect to delegation is set forth particularly in the Anderson case and the Levy-Delmont. The Anderson case, which we've cited, talks about how in instances in which administrative complexity renders it impossible to set forth a comprehensive, discrete standard, that you have to give a large amount of flexibility to the executive to implement the authority that's been delegated. In this case, we're talking about the authority to spend funds, and the authority is there because the legislature recognized that there is an overarching constitutional obligation to keep a balanced budget.
And what is the obligation of the executive branch to carry out the intent of the legislature once the legislature has passed a statute and the governor has signed it into law? What is the governor's obligation to carry out legislative intent?
Well, the governor's obligation is to see that the laws are faithfully executed. And in this case, the governor has to balance the fact that we have appropriations far in excess of the state's ability to spend.
Mr. Gilbert, I'd like to give you the same question, and I'll give it to your opposing counsel too. Is the unallotment statute a delegation of legislative appropriation authority, or is it a codification of the procedures for the exercise by the executive of his inherent authority over spending?
Your Honor, it is not a legislative delegation of appropriation authority. It is a delegation of authority to unallot for the very purpose of preventing a budget deficit, of preventing a financial crisis in the state of Minnesota for the state and for its respective citizens, and to comply with the constitutional mandate of a balanced biennial budget.
So if I understand your answer, it is that the statute is not a delegation of appropriation authority.
Absolutely not.
Mr. Robinson, let me ask you the question that I've asked your two colleagues. Is, in your view, the unallotment statute a delegation of legislative appropriation authority, or is it merely a codification of procedures for exercise by the executive of the executive's inherent spending authority?
Our position that it's delegation of authority.
Counsel, can I just want to make sure I understand. The Florida case, which you rely on heavily, Childs, discusses the two different strains of separation of powers inquiry, and it says there's the encroachment strain and the non-delegation strain. Do I understand you to be saying this case is about the non-delegation strain of separation of powers inquiry?
This case is about both strains, Your Honor. It's a delegation of authority, and to the extent that the statute did not authorize the commissioner to make the determinations he did, it's an encroachment upon the legislative's power.